Good afternoon. Order, please. We'll now begin meeting number 66. And we'll be pursuing our study of the Conflict of Interest Act. It's our great pleasure to welcome witnesses today. First, Mr. Guy Giorno and Ms. Frock for the Canadian Bar Association. Thank you for coming. We were supposed to have Mr. Dodek from the University of Ottawa. He won't be able to attend today. He'll come to another meeting, but we do have Mr. Boisvert from the École Nationale d'Administration Publique, who is a full professor. We'll begin with 10 minutes of opening remarks per witness, and then we'll move on to a period of questions and answers. I know members of the committee are all looking forward to this, and with no further delay, we'll move on to Mr. Giorno from the Canadian Bar Association. You have 10 minutes.
Ms. Frock will begin.
Thank you, Mr. Chair and honourable members. The Canadian Bar Association is pleased to appear before this committee today to address the statutory review of the Conflict of Interest Act. The Canadian Bar Association is a voluntary association of 37,000 lawyers across Canada whose primary objectives include promotion of the rule of law, improvement of the law, and improvement in the administration of justice. It is in the spirit of this mandate that the members of our Administrative Law section, through its Law of Lobbying and Ethics Committee, have made the comments that we have submitted to you in writing and will speak about today. Guy Giorno, an executive member of the CBA's Administrative Law section and the chair of its Law of Lobbying and Ethics Committee, is here with me today, and I'll turn it over to him to address the substance of our comments on the review.
Thank you, members of the committee. As Kerry said, I'm an executive member of the CBA's National Administrative Law section, and I chair the CBA's Committee on the Law of Lobbying and Ethics. Everyone covered by the Conflict of Interest Act holds a privileged position, and each has volunteered for public service. Au Canada, les charges publiques ne sont pas.
In Canada, public offices are not forced on anyone.
Or by accepting appointment or employment, each public office holder freely chooses this responsibility. Public office holders voluntarily accept the public trust, knowing they must maintain that trust and knowing they must be seen to maintain it. The Supreme Court of Canada has observed preserving the appearance of integrity is as important as the fact that the government possesses actual integrity. In this context, allow me to highlight a few of our recommendations. We agree with the Conflict of Interest and Ethics Commissioner that Parliament should close the loophole by which the Governor and Deputy Governor of the Bank of Canada are not covered by the Act. We support the Commissioner's call for greater transparency in reporting of gifts, including extending reporting to all public office holders and reducing the $200 thresholds. Perhaps the most significant shortcoming of the Conflict of Interest Act is that it lacks teeth. The Act contains 44 rules, 19 positive obligations or duties, and 25 prohibitions. None of the prohibitions and 1/3 of the duties are unenforceable. No one can be charged for breaching a prohibition under this Act. No one who defies a prohibition will pay a fine. Other than being named in a report to Parliament, there is no sanction for violating any of the 25 prohibitions or for breaching 1/3 of the duties under this Act.
The rule of law, then, is not served well. If the law sets out rules of conduct, then these rules have to be applied. They have to be applied effectively, and they have to be seen to be applied.
The current scheme results in unfairness and inequality under the law. Laws are drafted by civil servants and passed by politicians. When civil servants draft and politicians pass laws on ordinary citizens, those laws include penalties. When civil servants drafted and politicians passed the prohibitions in this law, which applies to senior civil servants and politicians and to political aides and political appointees, penalties were absent. We recommend that the Commissioner be given authority to impose administrative monetary penalties for all contraventions of this Act. We also recommend that the Act be amended to require the government to address and respond to each breach. Since the Federal Accountability Act was introduced in 2006, the Canadian Bar Association has been concerned about the restriction that prevents public office holders from belonging to a professional association like the CBA. Our recommendation 3 endorses the Commissioner's request for authority to permit a reporting public office holder to engage in outside activities where these would not be incompatible with the reporting public office holder's public duties or obligations. Political fundraising can give rise to conflict of interest issues, especially when the targets of fundraising are stakeholders of a politician's department, or when the funds are solicited from lobbyists who are lobbying the politician or his or her office or department. The Prime Minister has issued sound guidelines for political fundraising in the book called Accountable Government. Unfortunately, the fundraising rules in Accountable Government do not have the force of law and cannot be legally enforced. We recommend taking the Prime Minister's fundraising rules and writing them into the Conflict of Interest Act. We disagree with the Commissioner on automatic divestment of assets whose value could be affected by government policy. She wants to reduce from 1,100 to as few as 140 the number of people subject to automatic divestment, and to replace it with case-by-case divestment. We believe that automatic divestment of controlled assets should remain required of all employees of ministers' offices, except students. Contacts between lobbyists and ministerial aides number in the thousands. Much of this lobbying relates to decisions that could affect the value of publicly traded stocks and other controlled assets. This is reason to maintain the current law, which provides that no minister's office employee shall own a controlled asset. Finally, we are concerned that statutory reviews such as this one are not taking place during the time frames required by law. These statutory reviews are more than administrative or housekeeping matters. They were mandated by Parliament to provide a formal outlet for stakeholders and other citizens to comment on their experience with the operation of legislation that might have been controversial or passed quickly or embedded in omnibus bills. A review of the Conflict of Interest Act was required by July 2, 2012. However, the House of Commons did not assign this committee to conduct the review until December 10, 2012. The CBA is deeply troubled by the repeated disregard of deadlines established by statute. The Parliament of Canada Act should be amended to mandate the Speaker of the House to assign the appropriate committee for a statutory review if none has been assigned by the deadline. Merci. Thank you very much.
Merci de votre présentation.
Thank you very much for coming today. And Mr. Boisvert, you now have the floor for 10 minutes. I think I'll follow up on what my colleague has said and give you a few recommendations, but I'll be coming from a different perspective. I'll be referring to political science research. And our research has been based on the analysis of various scandals, on the institutionalization of government ethics, and we have also analyzed the recommendations from international NGOs or organizations such as the OECD. So we've looked at these references together in order to decide what should be done. Perhaps it's time not necessarily to look at the tools themselves, but how efficient these tools are. And we don't feel that there has been much of a concern for how effective tools are. So we need to have the means to make sure that our tools do ensure that mandates are met. Now, we have to look at the tools and analyses that are available to Canadians, that those who are responsible for implementing rules and ethics are able to fully carry out their mandate. And what we've noticed is that they're not able to because there has been a lack of resources. And I feel that this is one of the biggest concerns out there now in terms of ethics and integrity. I think that legislation should be much clearer than it is in the preamble in terms of the objectives and the goals of the legislation. It shouldn't just be a grocery list, a technical grocery list in terms of public office holders, because it's not obvious in the preamble that there is a specific goal to this legislation, which is to preserve the integrity of public decisions. And I think it would be important to emphasize that role, first of all. So we have to move from a technical interpretation of the legislation as opposed to sort of a living implementation of this legislation. So it has to be focused on ethics and integrity, and the main objective should be this. First, the public office holders should obviously have a social mandate. There should be awareness raising, ethics awareness raising on the part of public office holders. There should be an increase in the clarity of the sanctions and an increase in the severity of the sanctions. Because if they are not serious sanctions, then they will not have a deterrent effect on public office holders. And they will not convince public office holders that the government is serious about integrity. Now, there are three main areas that I think are particularly important. When you look at the various scandals, it's clear that there should be three priorities. First, it should be clarified what personal interests are. Often what this means is specific personal financial interests, but these interests are much broader than that. Many of the political scandals throughout OECD countries deal with, for example, funding of political parties. And so public decisions can be influenced because of personal interests, and those personal interests can include political parties. So it should be very clear that personal interests go much beyond individual interests of the public office holder. So when you look at the legislation, it's really rather restricted when it comes to a personal conflict of interest. But it can include much more than the immediate circle of the public office holder, and it can go well beyond the private sphere of that individual. So that has to be looked at. My second point has to do with gifts and other advantages. Now, in the 1980s and the 1990s, no one really knew that gifts may have any sort of impact or any sort of influence on government decisions. But when we took a closer look at the scandals, there seemed to be this incredible increase in the acceptance of gifts. And I would suggest that you look at the Charbonneau Commission and you look at the influence and the increase in gifts, because this has been increasing significantly. And as the OECD said very clearly, a gift is always a foot in the door in terms of corruption. So it's important that gifts not be accepted, because those gifts open the door to the next stage that lead to the acceptance of corruption. So the debate is not whether you accept $100 or $200. The debate should be whether it is acceptable to tolerate the public office holders accept gifts, regardless of what the nature of that gift is and regardless of what the size of that gift is. Anthropologists have showed that giving a gift is never just a gratuitous act. There's always an expectation of something in return. And the anthropologist could give you a very comprehensive definition of that. Now, one last point that I think is fundamental, and that is I think there should be a serious review of all legislation in terms of post-employment conditions. I think that that's probably the biggest weakness in the tools that we have in conflict of interest on the part of public office holders. Those who are responsible for managing those files, the post-employment files, have to have the necessary tools, and it's very clear that our legislation and the budgets granted to commissioners do not provide enough to be able to manage these post-employment conditions. In Quebec, post-employment circumstances have been quite problematic at various levels. Let's take Montreal, for example. In some cases, public office holders and elected office holders have immediately moved on to the boards of various companies. And so managing the post-employment activities is very important. In Quebec, the lobbyist commissioner has a very difficult job in applying post-employment conditions because really it becomes tempting to just look at the lobbying aspect of it. But again, post-employment activities can simply involve rewards for decisions that were made previously, and that doesn't necessarily fall under the lobbying activities. But sometimes there are hundreds of thousands of dollars involved in post-employment activities. So that is the reality. It exists throughout many OECD countries. My last point deals with my concern about governments providing the real means to those who are responsible to ethics and for ethics and integrity. So you need the necessary tools, and you need to have the budget that goes along with it. If you have too limited a budget and too limited resources, that can't be done. And we've seen that all too often at various government levels. So the challenge is to give the means, efficient means, to the commissioners who are responsible for ethics and integrity. And if possible, you also need to encourage senior officials throughout the Parliament of Canada to collaborate closely and work together in order to have a system that works. Whether we're talking about lobbying or ethics or conflict of interest or disclosure, these senior officials could be providing us with much more effective rules and regulation if they were allowed to coordinate that amongst themselves and if they were allowed to collaborate. And citizens of Canada might then be able to regain their trust in their institutions, in their political and administrative institutions. Thank you very much. And thank you to you for your opening remarks. With no further delay, we'll move on to questions and answers from the members of the committee, starting with Mr. Angus, who has 7 minutes.
This is a fascinating discussion. Mr. Journo, I certainly agree that preserving the appearance of integrity is the same thing as maintaining integrity. That's a fundamental. It seems to me also, though, if we are creating laws, laws have to be clear. If they're not clear, can they really be just? And my concern when we've been looking at this act, I have an incredible respect for the commissioner, but there's times when I look for clarity and I don't really know what it is. It seems it's a little loosey-goosey, particularly, for example, fundraising. When I ask the commissioner about gifts, and perhaps I'm in a different realm, I'm not a deputy minister, but I get offered baseball caps and cups, and if that's buying my vote, well, geez, I don't know. It all sits in a box. I don't mind announcing $30 worth of snow globes. It's not a problem to me. But when I ask about political fundraising, we don't really hear any clear answers and what the threshold is. And I'm concerned because it's not that we're trying to make our jobs impossible. We live, as you know, we live in the world of political money. That's what political parties live on. But there's got to be clear rules. And I'm asking for a sense of where's the line? How do we divide it? Is it that difficult to do? And I see in your brief you say we should have clear rules. So what would you suggest?
Well, first of all, Chair, the CBA position deals only with the Conflict of Interest Act. We haven't commented on the members' code, although there are, as members will appreciate, similar provisions. So speaking of the Conflict of Interest Act, we draw attention to the fact that in Annex B of Accountable Government, there are as concerns political fundraising by ministers and parliamentary secretaries, what we think are very clear and very thorough guidelines which seek to separate quite clearly the lobbying of and decision-making related to government policy from political fundraising. The member is correct that currently, as concerns political fundraising under the Act, there are no guidelines, and in fact there's only one rule, a very simple rule in Section 16 that applies to all fundraising. Simply says that you can't personally solicit funds. So we believe that at least in the area of political fundraising, again, as affects reporting public office holders, that's the only group of office holders covered by the Conflict of Interest Act, the specific rules in Annex B of Accountable Government should be imported into the Act and would provide, I think, a lot of the guidance and clarity that the member has asked for, at least under the Act, not speaking to the MP's code.
In terms of the issue of divestment of assets, the recommendation is assets of those, quote, who have a significant amount of decision-making. It seems to me that that's a very subjective interpretation. I see that your recommendations are saying that we need to have clear rules on automatic divestment. So what would you suggest?
Well, right now the current rules are clear. I mean, right now the current rule is if you're a reporting public office holder, you are subject to automatic divestment. Divestment is defined as selling or putting in a blind trust. So that's very clear. Our recommendations would maintain that clarity and maintain almost all of the automatic divestments, except in narrow cases, which I think, again, would be clearly defined. Interns or student, again, in minister's offices, again, a clearly defined class, and then allow the commissioner to exempt public appointees, that is governor and council appointees, where the nature of their mandate is so narrow, doesn't apply to multiple sectors of the economy, it applies very narrowly, and there's not likely to be an issue related to the decisions affecting the value of assets. The example we use is the immigration and refugee, for example. So our proposal would maintain the current clear requirement, narrow it very slightly, and only in clear ways. I agree with the member's question that for the Commissioner to say the automatic divestment rule ought not to apply to anybody except somebody who exercises significant authority leaves open a question. She names Chiefs of Staff to Ministers only. She does not mention Deputy Chiefs of Staff, Policy Advisors, Directors of Policy, all of whom we know talk on a daily basis sometimes to lobbyists who are lobbying on government decisions that would affect the value of publicly traded securities.
In terms of the administrative monetary penalties, the clarity of that, for us, it's an important issue because it allows to differentiate between errors in judgment and people who've done something wrong. How would you see the administrative monetary penalties? Are there limits? When do they start? Are there any have you built a context around how that would be applied?
Well, we begin with the rule of law. And this is a very important point, and that, Chair, the member's question allows me to underscore this. Parliament chooses which laws it makes and which laws it doesn't. In this case, Parliament has chosen to create 44 rules, put them in statute. They're not guidelines or policies. Parliament voted to put them in statute, 25 prohibitions and 19 mandatory obligations. It's open to Parliament to repeal them. In the case of every other law that I know of enacted by Parliament, that is the laws affecting common folk, there are penalties for those breaches. And then a lot of the considerations the member has asked about are dealt with in the judicial process. Many statutes, due diligence is a defense. Many statutes, there's a requirement of both the mens rea and an actus rea, that is a mental element giving rise to the offense and the actual activity giving rise to the offense. We trust the judicial process. The member's correct that there are sensitivities and balancing considerations, but for common folk, we don't say, well, because it's very difficult to look at, whether a law was broken or not. There are no penalties. Right? Ordinary people are subject to fines. They're prosecuted. What we think is a matter of rule of law is absolutely, utterly incompatible with the rule of law, is for those who write the laws to say, well, because of these considerations, for us, there are no penalties.
And the question, though, you'd also stated in your, I was looking in the brief about the obligation of government to report each breach.
Yes.
respond? So how do you frame that?
So right now, Section 19 of the Act says that compliance with this Act is a condition of a person's appointment or employment as a public office holder. We know there are right now under the few sections, right, the 13 of 44 rules for which there can be penalties. We know there are breaches. In the last 12 months alone, the Commissioner has found 17 breaches. We don't know, or it appears that there's not been any follow-up on that. We do know that, for example, those 17 public office holders were not removed from appointment or employment as a result of that. There was, in fact, as far as we can determine, very little attention paid in Parliament to those breaches, very little attention paid in the news media to those breaches. As a matter of the rule of law, there must be consequences attached to breaches. So our recommendation is that where there is a breach found, in addition to the penalty, the government that employs or appoints the individual will have to respond to the breach, saying, okay, having taken into account the breach, having taken into account Section 19, which says that obeying this Act is a condition of employment or appointment, here's our response. We're either going to maintain the employment or employment, and here's why, or we're not going to, and here's why. But what's not acceptable in our submission is for breaches to be found, again, the small number of rules that are capable of being penalized, right, under the Act as it now stands, and for nothing to happen as a result of them. And we do make a recommendation which applies to the government, although in our brief we do comment on the actual absence of scrutiny in Parliament and in the news media to these breaches. If this is a significant act and a serious act, and then breaches are significant and serious, and attention ought to be paid to them.
Merci, Mr. Angus. Merci de votre réponse.
Thank you, Mr. Angus, and thank you for the response. And Mr. Carmichael, you now have the floor for 7 minutes.
Thank you very much for your presentations this afternoon. They've been extremely interesting. And as you can well imagine, this is a topic that we're hearing a lot of different opinions on, but we're hearing some common ones as well. So that is very helpful. Mr. Boisvert, I wondered, you talked a bit about the clarifying of personal interests, and you felt that that needed to be one of the priorities. Is that, you feel that it should be clarified as a definition, like it should be better defined in that manner? And are there other definitions that need to be looked at as well? Could you comment on that, please?
Oui.
Yes. Yes, in fact, you said personal interests, and that's a word that isn't used very often. So often one's talking about specific personal interest, and the term has already been broadened from what it used to be. There are interests that can involve influencing in some way the decision of a public office holder. Let's take political parties, for instance. They may decide their gifts or these personal interests may have a certain impact on their decisions. So let's say a political party wants to be in a position to receive funding. Well, earlier on we were talking about gifts. And I think that there should be a debate on what gifts involve exactly and how funding of political parties enters into this. Because when it comes to what public office holders are actually going to do, let's take ministers, for example. These become important. There are ministers in Quebec who had certain standards that they had to meet when it came to fundraising, for example. And that could bring about some very negative consequences. So when there can be any sort of undue influence on a public decision, this becomes important. And it may mean that some may obtain funding more easily than others. So we need to broaden the definition. It's no longer simply a personal interest of the public office holder. We have to look at very specific interests. There are other examples of this. For example, There are, for example, close friends of public office holders who seem to obtain certain favors from them. So this also has to do with personal interest. Now, it's not necessarily within their immediate personal circle. We're not talking necessarily about their immediate family circle, but we are talking about an extended circle. And when there is any sort of influence on a public decision, then it can become quite questionable. Accurso had many, many friends. Mr. Accurso had many, many friends. And so then in that case, how were his decisions influenced negatively? So you also have to look at the perception of these decisions, and citizens may perceive to be these decisions to be influenced. So I think that personal interest has to be extended. And one has to look at how many interests may end up influencing decisions that may negatively affect public citizens.
Talked a bit about personal interests, and you've talked about friend and that definition, and perhaps it needs to be looked at too. And you've talked about gifts, and if I understood you correctly, I think you said there should be no gifts. And I just have a question. And I think those of us sitting at this table are not in a position where we, as just members of Parliament, receive much in the way of gifts. But what about cultural issues and things? Like, I think that there are some instances where ministers or others that have to report are in a situation where if they did not accept a meal or did not accept a cultural gift, it can be seen as a slight? Can there be differences made?
À ce niveau-là,
well, you said yourself that you don't receive many gifts, and I think that's a good thing, because in most public bodies and organizations, that's the case. I teach civil servants to think about this, and what we ask them to think about is that gifts should not have a place within these public organizations. And public office holders should set even a better example. So if we're telling our civil servants or other officials not to accept these gifts, well, then senior public office holders should do the same. Now, this is often debated. There's always the case of exceptions for, let's say, diplomatic office holders. So let's say they're on diplomatic missions. And so they're traveling abroad in different countries. And they are called upon to come in contact with various traditions, cultural traditions. Now, the experts have said that if they are in that position, then there has to be an obligation to disclose the gift that is received. And the gift should be provided when they come back to the country. So it should be provided to a body, an organization that is responsible for managing these gifts, these cultural gifts that are provided. And there are many ways have been proposed to do this. In some countries, for example, there are annual auctions that are held for the gifts that have been provided to public office holders. And then the money is given to, for example, not-for-profit organizations. So there are many ways to do this. And so that way you avoid problems. You don't have to be necessarily impolite. You don't have to end up slighting people, and you can accept the gifts. So I think we have to look at those kinds of scenarios rather than just opening up the standards, loosening the standards. Thank you, Ms. Carmichaels. Your time is up. You've had 7 minutes. We'll now move on to Mr. Andrews for 7 minutes.
To our witnesses for coming today, and we're seeing some common themes throughout our witness testimony in comparing to the Commissioner what recommendation her office has made. Mr. Journal, from your experience from being around this place, what is it about the Conflict of Interest Act, the 19 duties and the 25 prohibitions, that that public office holders don't seem to recognize those rules, or not that they don't recognize those rules. I think if you went to ask them, they wouldn't be able to tell you half of them if they had to spell them out. So is the problem that they don't? They know there's some general rules about conflict of interest, but the specifics of it, and will the penalties bring attention to paying more attention to them? Do you understand what I'm asking? Like, why is it that these 19 and 25, if you ask people, they probably wouldn't be able to name half of them?
Well, I think Chair, there are several requirements for the enforcement and upholding of laws. Some of them we haven't addressed specifically in our brief, but they're certainly a historic CBA position. So we've talked about resources, right? Those who enforce the laws must have the resources. That is a requirement. Education is important. So while it's not specifically addressed in our submission, CBA certainly believes that those who are bound by the law should be educated as the responsibilities. I think that's part of the answer to the member's question. If I understand the other part of the question, Chair, the member is asking whether the penalties are required, I don't want to put words in his mouth, but to make public office holders more aware of the restrictions on them. That's one reason for the proposal, but I don't think it's the primary reason. The primary reason relates to the rule of law and fairness and equality before the law. Ordinary people who break laws that are passed by Parliament face consequences, and it's simply incompatible with the rule of law that public officials who break laws made by public officials somehow get a pass. Secondly, with any law, there are issues related to deterrence. Right, penalties have a two-part or a twofold significance. One, they actually are designed to punish or impose a sanction on the wrongdoer. That's one of the reasons in our justice system we have penalties. The second is to send a message to everybody else, to deter people in future. So I think while the members got at part of the reason for extending the penalty regime, there are probably 3 or 4 other reasons as well.
I think the deterrence is a key issue in this, because, like you say, the commissioner can write someone up, but then there's no deterrence because, okay, I get writ up and slapped on the wrist, and I'm sorry, and then someone else comes along and does it and didn't really realize that happened to the last person. So when you look at the penalties, I think you're the first one to recommend a monetary penalty up to $25,000. You're pretty specific in that per contravention. Should we look at the $25,000 or the amount and look at the 19 and 25 and be a little bit more prescriptive? If it's one of these 19, the penalty should go to X, or if it's one of these 25, it should go to X.
Well, $25,000 is borrowed from 2 provincial statutes which relate to lobbying. Right? The administrative monetary penalty regime is fairly new. The alternative, and public office holders can choose this, is prosecution and imprisonment. That's the alternative, right? Ordinary people who break the law go before a judge and either are fined or sent to prison. So that's always an alternative. But if we're going to go to an administrative monetary penalty regime, which is fairly new, there's not a lot of precedent to look at. I mean, it's quite clear that a maximum penalty of $500 is not significant either to send a message to offenders or to deter others. $25,000, which is a maximum, again, like a court fine, would still require that the severity of the infraction and other things be taken into account is a model. But that's something the committee could review. And as I said, if public office holders are troubled by the idea of $25,000, the alternative is to do what happens to ordinary folk. Right? That is, you're charged, you're brought before a court, and you're fined or sent to prison. That's how the rule of law applies to everyone else in the country.
You refer to the 17 breaches that have occurred and there's been no response to. Which one of your recommendations refer to fixing that 17? And secondly, these are breaches that happen with the designated public office holders, and is there any level of privacy here with these individuals, or if you breach, that's part of it, you should be identified?
Let me see, Chair, if I can take the member's last question first and then go to his first question. Part of the rule of law is that the administration of justice is open and transparent. When ordinary people break the law, it's subject to publication bans covering young offenders and witnesses. Subject to that narrow area, when ordinary people break the law, their wrongdoings are made public. That's part of an open and transparent system of justice. That's why we moved away from star chambers. So openness and transparency in the administration of justice is a centuries-old right and principle that we observe here in Canada. So I don't see why public office holders should be any different, right? Common folk, their transgressions are made public. Public office holders shouldn't be in an exalted position in that respect. You asked about which recommendation dealt with the consequence of a finding of a breach. And I'll clarify again, that's 17 breaches in the last 12 months alone. There were more previous, and that only applies to the areas where the Commissioner can impose a monetary penalty, which is none of the 25 prohibitions and only 13 of the 19 positive obligations. It's our recommendation 17, which says that the Act should be amended to provide as follows. After the Commissioner's finding of a breach of the Act by a public office holder, the public office holder's employer or appointing authority shall be given 30 days to confirm the employment or appointment, as the case may be, and to publish reasons for the decision. If the employment or appointment is not confirmed within 30 days of finding of a breach, then the public office holder's office shall be vacated.
Thank you.
Merci beaucoup. Donc, maintenant,
Thank you very much. And now, Mr. Carmichaels, you do have the floor.
Good afternoon to our witnesses. Mr. Giorno, I just wanted to begin by asking about some of your recommendations in the CBA presentation. Recommendations 8, 9, and 10 all go contrary to the Commissioner's recommendations. You've added a good deal more people, and I understand you talk about common folks and some of the different nuances of people who have access, but I wonder if you could just address those three items as to, and I'm most specifically interested in boards where you've got appointments to boards and where you see the vulnerability, I guess, to the Act.
Sure. So to be clear, the Commissioner has proposed moving away from the current Act, and it's the CBA that actually, we're not trying to enlarge the Act here, we're actually trying to keep the Act more the way it is in this respect. And the difference of opinion relates to the difference between, Chair, automatic divestment and case-by-case divestment. So if I can, the Commissioner can speak for herself, obviously, but to explain her thinking as an introduction to explaining why the CBA takes a different view. Her thinking is that in many cases, it's enough to divest on a case-by-case basis. You're a public office holder, something comes before you, you own those securities, you report to the Commissioner, she tells you what to do, you either sell it or put it in a blind trust. It's our belief, that, and we don't quarrel with case-by-case divestment as a mechanism, that in the case of certain public office holders, they're coming into contact with decisions or issues that relate to publicly controlled assets will be so routine and frequent, case-by-case divestment doesn't make sense. It's simply not practical. I'll get to, Chair, if I could, appointees in a second, but we'll take a Minister's Office employee. I mean, it's the example of a policy advisor to a minister. They come into contact with lobbyists so frequently, and they're lobbying on so many issues, case-by-case divestment is simply impractical. Right? We think that the existing rule, automatic divestment, makes sense in that context. In the same manner, depending on the nature of the appointee, well, let's take, for example, if Parliament sees fit to adopt a recommendation to include the Governor of the Bank of Canada under the Conflict of Interest Act, should the Governor of the Bank of Canada divest on a case-by-case basis, or is it understood that he'll have such contact with such issues routinely that automatic divestment up front is the only way to go? Similarly, some of the boards, the CRTC, for example, is it even feasible to divest on a case-by-case basis, or would you expect that because the CRTC Commissioner has such a wide scope and mandate, the only practical course is what's already in the Act, which is you just get rid of your assets up front? Chair, I hope that explains or answers the member's question satisfactorily.
Well, no, it does, and clearly when you talk to that effect, I understand when you say that we as members of Parliament, we choose a certain life, and we run for this. I think it was Mr. Boisvert addressed that, and so we understand the ground rules on the way in. Is it fair to extend those same? I understand the breadth of exposure, but I'm wondering if it's fair to extend that to somebody from outside who's being brought into a board position.
Well, we're only talking, Chair, about boards where the appointments are made by the Cabinet or made by Minister, confirmed by Cabinet, and if our recommendations adopted, extending it to people like the Governor of the Bank of Canada who are appointed by other bodies and confirmed by the Cabinet. That totals 1,100 in all. Those are, by and large, fairly significant positions, and I'll say two things. Again, no public office is forced on anybody, including a board appointee. And secondly, those coming from the private sector, as the member will know, coming from the private sector himself, are familiar with issues of conflict of interest and rules. Those who are coming from corporate Canada are already in their own business lives and careers familiar with the conflict of interest regime, and in my view, would be quite understanding of the fact that accepting public office means that one is entering into the conflict of interest regime in that environment.
Thank you. I appreciate the explanation. When the commissioners asked to launch an investigation, there's always potential for public and external factors to create presumption of guilt prior to her conclusions being made known. And I wonder, do you see any way to mitigate the attacks on the reputation for purely partisan purposes? Something we see fairly regularly, and is there a way to mitigate that?
Well, one of the existing rules in the Conflict of Interest Act is the rule, I'm just going to look it up here, which provides that when a complaint is made by a member of the House of Commons, the member should not disclose that information to anyone except the Commissioner. That is one of the 25 prohibitions for which there's no sanction. So again, that Parliament actually decided that it would be appropriate that people who bring members who bring complaints won't talk about them until the Commissioners had her say. That's one of the unenforceable 25 provisions. So our recommendation to make that provision enforceable would go one way toward dealing with that. More to the point, I think the issues raised with the member are more generally dealt with by the openness and transparency, which is part and parcel of the rule of law. And the more open and transparent a process, the better able the Commissioner is to explain findings or to explain why something has not happened. Actually will create greater understanding, and greater understanding is probably the best way to deal with adverse impacts on reputation of those who are accused wrongly. So,
have I got a bit more time? So, following then a complaint where the Commissioner has dismissed it as unsubstantiated, and or an investigation where she's ruled that the conflict of interest has not occurred, quite often the individual being investigated will not know where the complaints come from. Do they have the right to know?
Under the Act, no, as currently drafted.
Right.
However, it is fair to say, and this is already covered, it's dealt with in our submission, and it's dealt with in certain sections of the Act already, 50 through 52, I believe, that when we enter into a monetary penalty regime, that is where people are subject to potential penalties for breaching the law, they're entitled to procedural fairness and natural justice. So to extrapolate from our position, if you're going to apply fines to every provision of the Act, which is what we're recommending, then the process for imposing those fines should be one which is judicial. It would include natural justice and fairness, and it is quite it would be quite appropriate and something that the committee can look into to apply the procedural safeguards and the principles of justice which allow you to know your accuser. Certainly, common folk who are brought before the courts know who their accusers are.
Merci, merci, Mr. Carmichael.
Thank you, Mr. Carmichael. Your time is up now. We'll now move on to 5-minute rounds, beginning with Mr. Boulris. Thank you very much, Mr. Chairman. Ms. Rock, Mr. Giorno, Mr. Boisvert, thank you all for coming today and for your very interesting presentations. Mr. Giorno, I fully understand your feelings about the flagrant injustices that public citizens are exposed to. There have to be penalties. And it's rather strange that anyone would be able to avoid that. I think sanctions and penalties are important. I'll come back to that. But Mr. Boisvert, I'd like to start off with you, and I'd like to thank you for clarifying the whole issue surrounding gifts. A gift, you're right, is never a gratuitous act. And you're right in speaking to that. And thank you for raising anthropologists as well. I don't think anthropologists are spoken about enough. And also thank you for speaking to specific personal interests. So as I understand it, the legislation itself is not the problem, but rather the mechanisms that we use to make sure that the legislation is working. So I have a broad question for you. What kind of extra resources or what kind of other mechanisms would you like to have in order to make sure the legislation is effective? And how could you make the Commissioner for Conflict of Interests be able, or do you think rather that she should have the opportunity to explain this legislation fully? Well, there are two parts to your question, and the first is this. The means. I mean, that is a fundamental part of the debate. It's not necessarily a debate on legislation. Obviously, legislation can always be improved, and I think that my colleagues have suggested good improvements for the legislation. However, what has been proven is that the biggest challenge is the means to be able to implement that legislation and to have it work in reality, in practice. And that's what I think the debate should be about. What do we need? And what does our Commissioner need in order to be able to fully meet the objectives that are set out in the legislation? So I think that's the biggest question. And then what indicators can we use or can be established in parallel with that legislation and with the means that are provided to the Commissioner so that every 5 years you are in a position to be able to assess whether or not the objectives have been met? So that is at the heart of the issue. Are we able to assess the efficiency of the legislation? There was a former integrity commissioner, and one of the problems at the time was that she wasn't meeting the expectations of the legislation in terms of disclosure. So that debate is important. What are parliamentarians' expectations? And can we set out those objectives very clearly? Can we set out even investigative standards that are clear? Does one pursue an investigation or not? And obviously, budgets are important. The problem often is money. Now, in the OECD, there were reports on measures that were taken. So there has to be disclosure. And from 2005 on, the OECD realized that one could have disclosure. However, it depended on the officials, and no results may happen necessarily if you had officials who weren't implementing this. So they need the means to do this. And I absolutely agree with the idea of sanctions and penalties. That has to be used to make sure that our public office holders think very carefully. Now, on personal interests, I said that there were four very important points. We have to have socialized public office holders. They have to be aware of their social responsibilities. In some of the research that I did with former ministers from the Quebec Parliament, 100% of them said that they had never been made properly aware of ethics and expectations. So when one is part of a parliament, and if one wants to respect and comply with legislation, then it has to be our duty to raise the awareness of new public office holders so they are aware of their duties. You have 10 seconds left. Thank you very much, then. Thank you, Mr. Bouleris, and thank you for the reply. And we'll now move on to Mr. Workington for 5 minutes.
Thank you to our witnesses this afternoon. We appreciate your testimony with regards to this matter. There seems to be oftentimes confusion between what the rules are and how they might be interpreted by a respective commissioner. One of the ones that I've been following somewhat is a case involving one of our colleagues, the NDP member Andrew Cash, who recently it was revealed that he was receiving over $40,000 on an annual basis from what is a Crown corporation, the CVC. What is disturbing is that he sits at the table of the Heritage Committee. When we had the commissioner here, she said that what happens at committee is noted and should be noted with regards to if or not there is a conflict of interest. In this case, there is not only a perception of conflict of interest, and I think that's been revealed by the media interest in this case, as well as members from several other parties, but there may be a real conflict of interest, because what we do note is that there was a letter that had been sent to the member indicating that he should refrain from voting on issues surrounding the CBC, as well as should refrain from engaging in debate with regards to this, both of which he's contravened based on the public record. I'm wondering, you've talked generally about the necessity of not accepting gifts. Well, if the limit of a gift is $200 and $40,000 is actually 200 gifts of $200, this seems like a significant issue, and one that the public has a great interest in. How might you suggest Mr. Cash undertake, or members of Parliament who find themselves in a similar situation as Mr. Cash, present themselves and undertake their responsibilities in a way that reduces the conflict of interest and both the perception of and quite possibly the real conflict of interest? Either of our witnesses.
Well, I think it's very difficult to take a specific position on something, on a specific file that you have raised. I don't think we're necessarily in a position to comment on a specific issue. I don't know if my colleague wants to comment.
You know, let's call it all hypothetical. But the Commissioner made it very clear when she was here that undertaking one's responsibility at committee needs to be separate from the presenting a conflict of interest, and she was absolutely clear. I'm wondering what you might suggest in a circumstance like this. Obviously, this gentleman is employed or has a contract with CBC, which is a Crown corporation, which receives appropriations from the federal government, from the Canadian taxpayer, that directly then support him and the cash payments that he receives. So I'm wondering.
Point of order, Mr. Chairman. I think this is a very specific case. We're all here in order to figure out how to improve legislation, not to ask for any legal opinion on a specific case. The Commissioner sent a letter to Mr. Cash about this, and he is compliant with the law. So before continuing, perhaps I could just point this out. I just want to say that it would be easier for the witnesses if we keep to the legislation, generally speaking, rather than refer to specific cases. So try to stick to the term public office holders as opposed to specific members. This is a review of the legislation. I'll allow you to continue your question, but if you could really speak to the legislation and not to specific cases.
I understand that you've ruled on this several times when Mr. Angus has brought forward names specifically alleging misconduct. What I'm interested in is not a ruling on this, and I think I've been very clear. What I'm looking for is a way, an avenue, to reduce this type of situation presenting itself in the future for any member of Parliament across party lines. This is one that's been high profile. It's been one that has caused Canadians from across this country to question the system. How is it that you have a sitting member of Parliament who is voting on appropriations to a Crown corporation or agency that is receiving funds from that agency directly? The question is how might we set up safeguards to ensure that this type of thing doesn't continue?
Well, one of our recommendations addresses this very directly. Now, the situation, the situation described by the member actually arises under the code, and the CBA has no position on the code. We do have a position on the Act, and our position on the Act includes a recommendation that every prohibition in the Act be enforceable by fine. The analogous, and again, the question related to the code, but under the Act, the analogous restriction is in Section 6 of the Act. Section 6 of the Act prohibits a public office holder from making decisions or participating in decisions when he or she has a private interest, as defined in the Act. Right now, there is no penalty for breaching that under the Act. There's no fine, there are no repercussions short of a report to Parliament. So I think the answer to the member's question is that the CBA recommendation that every single prohibition and the remaining 6 duties in the Act that have no sanctions attached to them be made subject to penalties, so that somebody who breaches that, granted the question was under the Code, but somebody who breaches the corresponding obligation under the Act would be subject to financial penalty.
Merci. Le temps est écoulé. Merci pour votre question.
Thank you. Your time is up. And we'll now move on to Ms. Borg for 5 minutes. Thank you very much, Mr. Chairman. And I, too, would like to thank the witnesses for coming today. Mr. Boisvert, you said that it's always difficult to manage these post-employment provisions and that perhaps there aren't enough resources, we haven't gone far enough. So I'd like to give you an opportunity to expand on what you said. And I'd also like to ask you, how could we improve that situation? That is, when someone leaves their public office, that they don't all of a sudden receive these huge controversial gifts. Well, post-employment is a difficult one, because this has to do with the right to have a career after your employment. So you can't just draw a clear line, and you can't necessarily prohibit them to have any sort of post-employment career, because that public office holder does have a right to continue on with other activities. However, the question is this: can we make sure that there is a follow-up of what is happening afterwards? Quite often, you have former public office holders who, less than 6 months after their departure, end up in firms that they have had various dealings with or contacts with. In some places, there have even been ministers who even negotiated their post-employment career while they were being employed, and this is a problem. And so, is it for the purposes, the question is it for the purposes of lobbying? Now, that's not necessarily the case. It's not necessarily just lobbying that has to be monitored. There's a broader issue. Were there any advantages or privileges that were granted? In the case I was referring to, there's a debate on various decisions that were made. And so the perception of this was quite negative. Was it a favor, for example, as opposed to just a free decision? So it's always a question of perception. And in that particular case, post-employment provisions appeared to have been negotiated while the public office was being held within government. So I think that those who are responsible for monitoring these provisions, post-employment provisions, should have a clear mandate to be able to monitor this for a specific period of time, whether it's 1 year or 2 years, depending on the public office that you held. So the means should be attached to that office to be able to monitor this, so that there is accountability afterwards. Perhaps every 2 or 3 months, for example, that former public office holder should have to disclose what they have done after their employment. And furthermore, perhaps there need to be sanctions or penalties, and perhaps my colleague beside me could follow up on this. Perhaps for non-compliance, there should be some sort of sanctions or penalties. And I think the Commissioner should have the means to be able to impose penalties on a former public office holder who is not compliant with those conditions and who ends up, for example, on the board of a company that they did deal with when they were holding that public office in the last 6 months of their term, for example. I think that might be an interesting avenue, and perhaps Mr. Giorno could follow up on that, because it seems to me that those penalties should be a central tool to this. Thank you very much. I would like to hear your opinion, but I only have 5 minutes. So I'll put my next question, and then perhaps the 2 of you could speak to that, or one of the 3 of you could speak to that. Mr. Boisvert, you said you spoke to these specific or private interests. I don't necessarily want you to give us a definition, but perhaps there is some sort of international model that is working. You could refer us to that. Perhaps you could direct us. Well, in terms of institutions, I agree with my colleagues. That is that all governments are in a position of conflict of interest at some point in time when it comes to defining their own legislation. All public office holders throughout the world actually benefit from their positions and benefit from weaker provisions. So I think it's up to international bodies, organizations who can provide us with models. Now, when it comes to, for example, broadening private or personal interests, you need to look at circumstances, various circumstances. Let's take community networks, for example. Let's take various groups that may be able to benefit from a decision, a government decision, because they're part of that circle of the public office holder. It may not be a personal relation that will benefit, but that network within their personal sphere that goes well beyond their immediate family circle that may benefit. So we're not just talking about children and spouses. So what you have to do is extend that circle. You have to have a broader circle. And then you can look at things like political parties, various networks, various associations, various other groups. Quite often, this extended circle actually has ended up benefiting from that public office holder. And what that does is run counter to the public interest when you end up favoring one group over another within that broader circle. So for the purposes of this debate, there is a conflict of interest. Conflict of interest means non-compliance with a public interest when you're benefiting private interests. So that means the decision was not made for the public good. It was made for other interests. And that's what should be absolutely clear in the legislation. At all points in time, any government decision has to be based on a public interest. That has to be your indicator. The decision has to be made for the benefit of the public good and not for the benefit of any sort of personal interest of any type whatsoever. And so I think what we have to do is review the legislation and extend that circle and that definition. Thank you very much. Your time is up. We'll now move on to Mr. Butt for 5 minutes. Thank you very much, Mr. Chairman.
Very much for being here and appearing before the committee for, I think, this important statutory review of the Conflict of Interest Act. One of the things that I think we're finding out as a committee is that there's some similarities and there's also some conflicts and some differences between both the Conflict of Interest Act and the Lobbying Act. I'm going to assume that both of you learned gentlemen are familiar with both of those pieces of legislation. The committee has found that the term designated public office holder, which is housed within the Lobbying Act, has many similarities to the term reporting public office holder. If they were to be more aligned, if we were to get a better definition so that they're covered in both acts, which act do you believe maintains a better single symmetrical definition of those individuals? Do you want to start, Mr. Journal?
Yeah, thank you. So the CBA's position under both the Lobbying Act and the Conflict of Interest Act is that post-employment restrictions should be harmonized for the reason the member alluded to, so there's greater understanding and clarity and administered by a single person. That said, there's always a but. The task of harmonization is actually quite challenging and difficult. The Conflict of Interest Act right now imposes restrictions not just on paid lobbying but unpaid lobbying for a shorter period of time. The Lobbying Act imposes restrictions on all lobbying, but it's got to be paid for a longer period of time, and then it exempts people who work for corporations who don't lobby 20% of their time. So a decision has to be made as to, in harmonizing, is it more important to go for the paid lobbying or longer period, or what about unpaid lobbying after you immediately leave? Designated public office holders is in fact a wider class. Reporting public office holders includes only public servants who are appointed by order in council, so that's deputy ministers and people of deputy minister rank, whereas the designated public office holder position goes to the level of assistant deputy minister. The CBA actually has no position on how to harmonize, but I do stress that the DPOH, the so-called designated public office holder category, is broader so it would cover more people. And while there is no official CBA position on this, obviously in the interest of covering more, I mean, harmonizing that would one way would cover fewer people, and therefore be less likely to achieve the purposes of either statute.
Okay. Monsieur Boisvert, did you want to comment on that as well?
Non, à ce niveau-là, c'est bon.
One of the things that I'm trying to figure out, and it doesn't affect me personally because I'm neither a parliamentary secretary nor a cabinet minister, is that 308 individuals are elected to Parliament. We're all elected to do the very best we can for our constituencies and also to advocate for our constituents on a wide range of issues. You probably are aware that there's been a couple of instances lately where the Commissioner has ruled essentially saying that cabinet ministers and parliamentary secretaries, simply because they are cabinet ministers and parliamentary secretaries, essentially can't write letters to support anything a constituent is proposing to do on a wide variety of things, even if that matter has absolutely nothing to do with the ministry in which they are involved. Is that a fair restriction? If the Conflict of Interest Commissioner is interpreting the Act correctly, and I'm assuming that she's doing her very best to do that, is that a fair restriction? I mean, you're a member of Parliament, you're elected to advocate. You happen to be asked by the Prime Minister to take on an additional responsibility through a ministry or as a parliamentary secretary, and all of a sudden it sounds as if the interpretation is, well, you're really no longer a member of Parliament. So is there a way that we can have some better definition around that? Why shouldn't a Minister of the Crown be able to write a letter in support of a constituent as a local member of Parliament on a local constituency issue, or do you feel that that is a reasonable restriction, that once you've been appointed to cabinet or as a parliamentary secretary, that essentially you're no longer a member of Parliament? Well, the interpretation which is described by the member is true. That's how the Act is interpreted and now stands. It's not entirely inconsistent with the history of the position of public office holders like ministers and parliamentary secretaries, and it does recognize the fact that the people we're talking about, who may be the recipients of letters or recommendations, are themselves people who are appointed by cabinet. So there is a question whether it's appropriate for a cabinet minister who may be in a different portfolio nonetheless to write a letter to somebody who's a cabinet appointee, a public officer, whether that's appropriate. And the second point to be made is that as our system of justice has evolved and become more complex, we have, this is over decades and centuries, we have less and less being decided by judges, and we have more and more legal matters being decided by independent tribunals, the CRTC, Canada Industrial Relations Board, et cetera, et cetera, et cetera. In fact, it's probably safe to say that more legal decisions are made by tribunals and administrative agencies than by the courts. If one would not accept a Minister of the Crown writing to a judge, is it any different for a Minister of the Crown to write to a CRTC Commissioner who's got the same sort of statutory power of decision? So the CBA section has not recommended any changes to the Act in this respect, and I think that it's safe to say it's because we believe the Act is appropriate in this respect for some of the historic reasons that I've outlined.
Monsieur Boisvert, est-ce que vous voulez ajouter quelque chose?
Mr. Boisvert, did you have anything to add? I think what's interesting here is this. We've undertaken studies that focus on former ministers, and ministers understood what the dilemma was. They understood that in terms of ethics, you had to be able to manage that line between being an MP and being a minister, and that it was very important to understand this. For example, you had to be able to identify whether the file really dealt with the MP or the minister, and I think it's very important to make that distinction, and I think the legislation actually does that. So, for example, when a minister signs something, that holds a different weight than an MP's signature. So when it comes to a constituent in their riding, for example, I think they have to be able to play their role as an MP, but they have to be careful nonetheless that that signature does not negatively affect their own public office, which is that of a minister, because then that does have a different kind of impact on their own government. And it also has an ethical impact. So he has to be able to acknowledge that. So I think that's important to think about, not just in terms of the legislation, but in terms of how a minister is able to manage that line themselves. And a minister must be made aware of the ethical issues involved in their public office. Thank you for your answer. And Mr. Boulris, you now have the floor for 5 minutes. Thank you very much. And thank you, Mr. Boisvert, what you're saying about being able to make that distinction between the role of a member of parliament and the role of a minister. And we've seen it in the news with the Minister of Finance who had his knuckles rapped because of this, making that mistake. Now, Mr. Giorno, I have a question to you on the kinds of penalties you would recommend, because you said that the legislation doesn't have enough teeth, doesn't have enough penalties. We've spoken about monetary penalties. There are also prison terms, such as those that exist in the United States. Could you give us other examples of the kinds of sanctions that might be taken against a public office holder?
With which I'm more familiar, Chair, there really are three sets of options. There's an administrative monetary penalty regime, which, as I said, is newer, but is increasingly common in Canadian jurisdictions for this sort of infraction. There's the standard offence and penalty prohibition, which either provides for fine or jail term, and that requires charges by the police, prosecution, finding by a judge, imposition of sentence. And the third sort of sanction, which we see in some legislation, including some provincial legislation of this nature, very famously the case involving the Mayor of the City of Toronto, is legislation that provides a penalty of vacating a seat. But those are, in the Canadian context, those are really the three choices or streams or avenues that Parliament can choose to enforce laws of this nature.
Merci beaucoup de votre réponse.
Thank you for that response, Mr. Giorno. Mr. Chairman, I'm now going to share my time with Ms. Borg. Thank you very much, Mr. Chairman. You spoke about the failure of this government to modernize a conflict of interest legislation. It's made another, I think, they've failed in another respect, I feel. So therefore, I would like to table a motion right now that in response to the public concern over recent data breaches that have affected more than 500,000 Canadians, the Standing Committee on Access to Information, Privacy and Ethics conduct a study relating to mandatory reporting to the Office of the Privacy Commissioner of incidents of data loss or breach, as well as providing the Commissioner with appropriate order-making powers, and that the committee report its findings and any resulting recommendations for modification to the Privacy Act to Parliament. Mr. Chairman, there was a huge data loss involving more than 500,000 Canadians. We also have access to information legislation that covers what departments need to do when there is a data breach or data loss. And unfortunately, that legislation has not been amended since 1985. And there was no such thing at the time of, for example, USB keys that could be lost with all that data. So it has to be updated. And I think we owe this to the victims of the data loss. We owe them a consideration of this legislation. It is our responsibility as a committee to do that. We are the committee dealing with privacy of information, and that's what this deals with. I would like to have everyone's support on this. I think it is our duty as parliamentarians to review this legislation, and it is also our duty to see how we can do that, how we can improve it. Thank you, Mr. Chairman. Mr. Boulris was the last one on the speakers list, so I'll allow the witnesses to take some time to leave. I understand that you have wrapped up your time to speak and will be moving on to a debate on the motion. So I'd like to give our witnesses time to leave and suspend the debate so that we can come back to this. So I'd like to thank again our witnesses for coming today, and thank you for your contribution to our study.
Alors, je rappelle...
Order, please. We'll now continue. Ms. Borg tabled a motion. There were 3 people on my list, starting with Mr. Workington.
I appreciate my colleague bringing forward this motion. It's one that has been considered, of course, by the Human Resources Committee. Obviously, our government believes that this is an unacceptable breach, this personal information. While it hasn't, all indications are that it hasn't fallen into the hands of those that would use this for inappropriate purposes. We do believe that this is an unacceptable breach and something that needs to be reconciled, and that's why the Minister has acted as expeditiously as she had on this matter. In terms of this issue, I think that there's a number of elements that will tie into the study that our committee has yet to conclude. As well, again, I do know that the Human Resources Committee is looking at this exact matter, but I do think that there's some subject material as it relates to our study that is in the context of that, and we've dealt with that in camera, and so I'd like to move the continuation of this discussion to camera.
Alors, la motion d'aller huis clos
The motion is to move in camera. It has been tabled. There has been a request for a recorded vote. No debate on this motion, so the clerk will proceed to a record.
Mr. Butt, Mr. Calkins, Mr. Carmichael.
Yes.
Ms. Davidson.
Yes.
Mr. Workington.
Yes.
Mr. Dreeshen.
Yes.
Mr. Mays.
Yes.
Mr. Julian.
Completely inappropriate. I vote no.
Madame Borg.
No.
Monsieur Boulris.
Bien sûr que non.
Monsieur Andrews.
Secrecy.
la motion, le greffier me rapporte que la motion.
So the clerk tells me the motion is adopted. We will suspend for a few minutes in order to be able to move in camera.